Oregon v. Mathiason, Supreme Court, 1977. Per curiam. Respondent Carl Mathiason was convicted of first-degree burglary after a bench trial in which his confession was critical to the state's case. At trial, he moved to suppress the confession as the fruit of questioning by the police not preceded by the warnings required in Miranda v. Arizona in 1966. The Supreme Court of Oregon described the factual situation surrounding the confession as follows. An officer of the state police investigated a theft at a residence near Pendleton. He asked the lady of the house, which had been burglarized, if she suspected anyone. She replied that the defendant was the only one she can think of. The defendant was a parolee and a close associate of her son. The officer tried to contact defendant on 3 or 4 occasions with no success. Finally, about 25 days after the burglary, the officer left his card at defendant's apartment with a note asking him to call because I'd like to discuss something with you. The next afternoon, the defendant did call. The officer asked where it would be convenient to meet. The defendant had no preference, so the officer asked if the defendant could meet him at the state patrol office in about an hour and a half, around 5 p.m. The patrol office was about 2 blocks from defendant's apartment. The building housed several state agencies. The officer met defendant in the hallway, shook hands, and took him into an office. The defendant was told that he was not under arrest. The door was closed. The two sat across a desk. The police radio in another room could be heard. The officer told defendant he wanted to talk to him about a burglary and that his truthfulness would possibly be considered by the district attorney or judge. The officer further advised that the police believed defendant was involved in the burglary and falsely stated that defendant's fingerprints were found at the scene. The defendant sat for a few minutes and then said he had taken the property. This occurred within 5 minutes after defendant had come to the office. The officer then advised defendant of his Miranda rights and took a taped confession. At the end of the taped confession, the officer told defendant he was not arresting him at this time. He was released to go about his job and return to his family. The officer said he was referring the case to the district attorney for him to determine whether criminal charges would be brought. It was 5:30 p.m. when the defendant left the office. Our decision in Miranda set forth rules of police procedure applicable to custodial interrogation. By custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Subsequently, we have found the Miranda principle applicable to questioning, which takes place in a prison setting during the suspect's term of imprisonment on a separate offense, and to questioning taking place in a suspect's home after he has been arrested and is no longer free to go where he pleases. In the present case, however, there is no indication that the questioning took place in a context where respondent's freedom to depart was restricted in any way. He came voluntarily to the police station, where he was immediately informed that he was not under arrest. At the close of a 1/2-hour interview, respondent did in fact leave the police station without hindrance. It is clear from these facts that Mathiason was not in custody or otherwise deprived of his freedom of action in any significant way. Such a non-custodial situation is not converted to one in which Miranda applies simply because a reviewing court concludes that, even in the absence of any formal arrest or restraint on freedom of any movement, the questioning took place in a coercive environment. Any interview of one suspected of a crime by a police officer will have coercive aspects to it simply by virtue of the fact that the police officer is part of a law enforcement system which may ultimately cause the suspect to be charged with a crime. But police officers are not required to administer Miranda warnings to everyone whom they question, nor is the requirement of warnings to be imposed simply because the questioning takes place in the station house or because the questioned person is one whom the police suspect. Miranda warnings are required only where there has been such a restriction on a person's freedom as to render him in custody. It was that sort of coercive environment in which Miranda, by its terms, was made applicable, and to which it is limited.